On behalf of the Beverly Hills Bar Association, hello and welcome to all our members and viewers around the world. I'm Adam Siegler of the law firm of Greenberg, Traurig. I'm the incoming president of the BHBA. It's my pleasure and privilege to welcome you to the fourth program of our War Stories series, featuring top litigators discussing some of their greatest cases. This program of War Stories was created by my friend and colleague Alexander Rufus Isaacs, incoming VP, and also by the BHBA litigation section. In today's program, we talk with legendary entertainment litigator Marty Singer of Lavely and Singer about his 2013 trial victory for RyanO'Neal against the University of Texas. This was a case involving a dispute of the ownership of a portrait painted by Andy Warhol of Farrah Fawcett, whom all of you will recall. And she was the love of RyanO'Neal's life, and RyanO'Neal was Mr. Singer's client. Mr. Warhol had painted two versions of this portrait, and he had given one to RyanO'Neal and one to Farrah Fawcett, who donated it to the University of Texas. After Farrah died in 2009, the university claimed that it owned both of the portraits. And there was a hotly contested jury's trial lasting almost a month in Los Angeles Superior Court. And as everybody knows, the jury found in favor of RyanO'Neal. So today we're going to get the inside story on how that case arose and how Marty won it. But before we begin, a couple of quick housekeeping announcements. For those of you getting MCLE credit, you will receive your MCLE certificate and a copy of the program in about 1 week. And after the program, would you please take the time to complete the survey, because it's very important for us to hear what you think about our program and how we can do better every time. On membership, and if we could put up the membership slide, I wanted to bring everybody's attention on the screen to the 3 new membership levels that the BHBA has launched to recognize that everybody has different needs and interests in the Bar Association, and we want to be responsive to that. And so you can look online at bhba.org/membership and see all the details on these. We encourage you to get active and involved and engaged in the BHBA. Now more than ever, we are a worldwide organization. So I know I'm speaking to viewers literally from around the world, including England and India, and we welcome your participation. So please join and participate and stay engaged. Today, we have a little bit more time, more like an hour, because there's so much to go over here with our distinguished guest. Marty Singer is literally a lawyer in the entertainment world who needs no introduction whatsoever. He is a celebrity litigation attorney who is himself a celebrity. He was born in Brooklyn, New York, and his parents immigrated from Europe. And to pause on a serious note, Marty, I believe your mother survived Auschwitz, is that right?
Yes, that's correct.
Yes, and so that's a tribute to how powerful a force the immigrant community is in the United States. You know, this is something where someone can survive a concentration camp, and her son can go on to be the premier entertainment lawyer in Beverly Hills. So I think it's tremendous. I want to talk a little bit about Marty's background. He went to City College of New York. He graduated summa cum laude while working full-time in the family business. And then he went to Brooklyn Law School, again, while working full-time. He was admitted to the New York Bar in 1977 and the California Bar in 1978. I would say that Marty has a star-studded roster of clients. That's a phrase that's often used, but here it's absolutely true. They include Sylvester Stallone, Arnold Schwarzenegger, Bruce Willis, Halle Berry, Nicolas Cage, Tommy Lee Jones, Charlie Sheen, Stevie Wonder, Simon Cowell, John Travolta. I could literally go on for half an hour. And so this is a testament to the ability that Marty has to get the insight into these cases, these celebrity cases, and to think them through and analyze and win them. And he's on every single list of top entertainment litigators you can find in the country. He's been in Super Lawyers for more than 15 years. He's in Chambers USA for every single year, including the #1 entertainment lawyer, 2008, 2010, 2011. He's in the Best Lawyers of America for entertainment. He's consistently in the Hollywood Reporter-esque report of top entertainment lawyers, and Variety in 2017, 18, and 19, he was one of the top 500 people in entertainment, period. In other words, that's including all the other studio heads and everybody else. Marty Singer is one of the top people. That culminated, if I may say so, in his recognition as the Entertainment Lawyer of the Year by the Beverly Hills Bar Association in 2012. And that, again, was a star-studded event, which featured not only our guest today, but Sylvester Stallone, Sharon Stone, Tom Arnold, and surprise guest Charlie Sheen for what was itself a very entertaining program. But Marty's also giving back every year. He's on the board of City of Hope and the Jewish National Fund and many, many other charities and good causes. Marty, it's great to have you here. We're honored to have you here. And one of the things I want to say is that even though my firm and Arnold and Lavely and Singer might be on opposite sides of cases, one of the enduring values of the Beverly Hills Bar Association is the concept of civility and collegiality, so that we can fight very hard in court on every case that we have, and yet we are still friends and colleagues, and we like to share moments together outside the courtroom. So with that spirit and introduction, I have to ask you, Marty, how does a nice Jewish boy from Brooklyn wind up as the heavyweight Hollywood hitter that you are today?
I don't know. I wanted to be a sportscaster, but I was told in college, well, if you want to start, you might as well move to French Lick, Indiana, or Oshkosh, Wisconsin, and try it out. But that's what I really wanted to be. But I almost fell into this field, unfortunately, when my father passed away just before, after my first year at college. I wanted to be an engineer, but not really. I just was good in math and science, and couldn't stand dealing with sympathy of dealing with patients as a doctor. But someone up there must be looking over me, and I decided I'll become a lawyer, and I've loved it for the last 40 years or so. And I still love what I do, and have always looked out for my clients. I have the greatest partners, the greatest lawyers and staff, assistants, file clerks, and it's a privilege always working with everyone in my firm. And I love what I do.
Thank you. Well, as I recited from the many clients that you have, you must have been doing something right over these last 40 years. So let's jump right into this case, the RyanO'Neal Farrah Fawcett case involving the Andy Warhol portrait. And I've just mentioned three icons in the art and entertainment world. Why don't you tell us a little bit about how this case arose and how you got into it?
Well, the case came into the firm, and I get many cases on a regular basis, and this just happened to come in. In fact, we started to deal with this matter before the lawsuit was filed, because we became aware that there was an issue regarding whether or not RyanO'Neal had the right to hold and keep his Farrah Fawcett portrait. And so we got involved in this case before we got involved with the University of Texas, and people may not know much about University of Texas other than, thank God, they have a horrible football team lately. There was not a lot of love between me and University of Texas. In fact, one of the first voir dire questions, we'll get into that in a few minutes, that they didn't want the jury to know, and I don't know if everyone here listening would know or participating would know, University of Texas is perhaps, I think it has the second biggest endowment of any college in the country or university. Harvard is number one. And I believe University of Texas has an endowment of over $30 billion. They have more private airplanes than I have lawyers. I think they may have more private airplanes than I have, including my staff. But in any event, so it was going against one of the biggest, most powerful potential plaintiffs when we ultimately got into this dispute with them. And there was nothing that they were not going to stop, including they hired someone who I wasn't that close with during the trial. They brought in one of the greatest trial lawyers in Texas, and Texas has these great trial lawyers, individual by the name of David Beck. We have since become friendly. I've referred business to him. We refer business to each other. But they brought him in. He's known as the lawyer in Texas that if you think you're going to lose your business, he's the guy to go to. And there was nothing to stop them in this case. This was a case that was, we want that painting, whether it's ours or not, and we're going to do whatever we can to get it.
let's talk for a minute about how these paintings came to be. I believe that was back in about 1980.
Well, it's interesting because people may know who Andy Warhol was back in, actually today he's died, but in 1980, actually before 1980, in the late 60s, RyanO'Neal, who was a big TV star, done movies, and then he did his iconic film Love Story, which many people may not realize now, but it was a big film 50 years ago. So I'm sure most of the people listening in perhaps weren't even born then. But it was a great film. But they became close friends. And then Farrah Fawcett was known for a television series known as Charlie's Angels. But actually, she was even more famous at the time. She had a poster that may have been the highest selling poster. They had more schoolboys or young men had this poster of her wearing a red bathing suit with her beautiful blonde hair. And she was like America's sweetheart, one of the most famous celebrities in the world. And Ryan and Andy were friends. And in early 80 or late 79, right around then, Andy Warhol was not known as, he was known in New York and LA. The rest of the country, they didn't really know who he was. Maybe they knew about him in Chicago or Miami, but for the most part, he wasn't as well known as he was later. And so 2020 decided, there's a TV show that's still on the air, so that's now been 40 years. They decided they want to do a piece on Andy Warhol. So he came over to RyanO'Neal and said, I have a great idea. Why don't I have Farrah Fawcett pose for a portrait, because he did famous portraits of celebrities. And then when I do the portrait, it'll be on the end, then I'll give you a portrait. And Ryan said, wait, you can do the portrait, but there's got to be one for me. Nicely, he said, of course, I'd like to get one and one for Farrah. He says, great, no problem. Nothing in writing, no contract. Farrah Fawcett passed away by the time of trial. Andy Warhol died, so you got RyanO'Neal. Now, what's interesting is, and I'll get into this in a few minutes, is that our position was, before the even trial started, we were aware of another interesting fact that I think most people are not aware of. And maybe they were aware of it if they read about the trial. Everyone knew that Farrah Fawcett was one of the most famous models, famous actresses. I don't know if she was a model, but she did, commercials and things of that sort and print ads. She was a great artist. And I have a lot of celebrities that are fantastic. Sylvester Stallone has had art shows. Others are, they really, and they sell for love. But Farrah was different. She did her art, and that's what she did. Her house, she gave gifts. She was a great sculptor, great artist. But what was interesting is, when she went to the University of Texas and started out there, they really honed her craft. There was a professor there, and she became a great artist, and she loved it. And when she did her will, she said, I want to give my art or artwork to the University of Texas. She had a son who survived, Redmond O'Neal. And so the question is, was that art intended to go to the University of Texas, namely the Warhol portraits? And so, as I told you earlier, one portrait was supposed to be with Ryan and one portrait was supposed to be with Farrah. But before Farrah died, and it's a long chronology, you don't have to get into it, but let me just give you the key fact, what happened. After these portraits were given to Ryan and to Farrah, they both had at their homes for approximately, I'd say about 16 years, 15, 16 years. Actually, about 17 years or so. They each had it separately. And this was a key fact in the case. Well, one day, Ryan and Farrah have never been married, but they loved each other. They were a couple, and that is Ryan's love of his life. They really were close as can be, but they had ups and downs like many couples. But unfortunately, one day, Farrah came to Ryan's place in Malibu, and she caught something that he obviously didn't want to see. He was with another woman in bed. And unfortunately, above them was it was his portrait of Farrah. And so there's an issue of what happened. University of Texas position was, at that time, she demanded to get back that portrait. It was hers. That was not Ryan's position. But afterwards, there was discussion, and it wasn't right away, but Ryan said, fine, you know what, you can have the portrait. Stay at your house because we're at the beach. I don't want it'll affect it. And it went there. And when we'll get into the more details, but at the time that Farrah died, both portraits were in her house. And within a few days of her passing, Ryan got permission from the trustee, because the trustee knew, who was their longtime businessman, that he can go retrieve the portrait. So the University of Texas claimed this was her portrait. He knew it, she knew it. She caught him cheating, she wanted it back, and it was in her house when she died. And there's a presumption, like they say, possession is 9/10 of the law. So there was a presumption in their opinion that in fact they had the legal right to the portrait. Now, our position was they didn't have the right to get any of those two portraits of Farrah Fawcett that was done by Andy Warhol, because it wasn't her art. And I'll get into that later. But in any event, the trustee made the decision, here's one piece of art, take it. If you want to sue Ryan, go ahead and sue him. We're not going to stay in your way. And that's how we got into this lawsuit.
Let me pause for just a second. Can we put up the two portraits for just a second? I want to make sure everybody has them in mind.
Now, I just want you to know, I don't know if somebody threw some, the portraits were both in color, and they were virtually identical because Farrah did one sitting, and they were both originals. These are not, you can always get prints. And although one looks black and white, it was not, but it was literally virtually identical. And it's important because what the University of Texas wanted was both portraits, allegedly side by side, or they could have, I don't know if they needed to sell it with a university worth over $30 billion. Ryan, on the other hand, that portrait was his love. It was the love of his life. It was above his bed, and he wanted something to happen. When he passed, he wanted that portrait to go to their only child, Redmond O'Neal. Now, what's very important, and what happened in the trial, and we don't, you could take off the portraits now, although they were virtually identical when we were at trial. The key issue, well, I made it the key issue in the case, not with the University of Texas. Here's the interesting thing. Farrah Fawcett wanted to give her artwork to the University of Texas. Beautiful artwork. And it'd be great. And so you understand, the University of Texas has, I think it's in Austin, one of the biggest museums. In fact, it may be the only cultural thing going in the University of Texas other than going to Trump rallies. No, but in any event, it really is a huge museum there, and it's very well known, internationally known. And so Farrah Fawcett, as a student who was there 3 years, and one of the reasons she became very well known is it's very important in Texas to be there are beautiful women in Texas, and she's one of the first, if not the first, person who was a student at the University of Texas, won Miss University of Texas as a freshman. And then she became hugely known, and because of that, she became an actress, and because it became big news at the time. But she wanted her artwork, all of her artwork that she had in her home, in a studio. I have to ask my partner, Todd Egan. He's brilliant. He worked with me on the trial. We never would have won the trial without Todd. I hope you're listening. He knows all the details. I know the details as well. But I don't know if there were over 100 or 100. There were an enormous amount of artwork. There were hundreds of pieces. Well, you know what happened after they got this great bequest? And wouldn't it be cool to go into a museum and you see one of your students did this wonderful sculpture and art by Farrah Fawcett? Yeah, Warhol is nice. Yeah, it's beautiful for the University of Texas to have a Warhol portrait up there. Well, guess how many pieces of Farrah Fawcett that she did that were on display in the University of Texas? It's a multiple choice. I'll give you the answer very quickly. 0. every piece of art that she did. Maybe there was one other in someone's office, but it was not in the. It was clearly not in the museum. It was somewhere in the catacombs. Who knows what they did with it in boxes? And I don't even know if they've ever put it out, even after the trial 7 years ago. But they wanted this valuable portrait of hers, and they couldn't care less about what she wanted. Was my artwork to be seen by the rest of the world? Well, they're in boxes as of the trial. And so that was a big theme of the case. And that was a big fact, which is very important when you try a case, because let me just say this, going into this case, if you had to ask University of Texas, what are your chances of winning? They would have said 99.99%. You would ask my chances of winning? Less than 50. But I have a lot of confidence in me. I have a lot of confidence in the facts. And I have a lot of confidence in the American jury system.
Well, let's set up the pleadings for the litigators in the audience then. So who sued whom, and where was the case filed?
So University of Texas sued RyanO'Neal in downtown with, and it was in court. And the case was pending. And this was a case clearly, there are people on this, that are listening, I presume some lawyers, some non-lawyers that are litigators, some transactional lawyers. I don't know what the ratio is, Adam. What do you say the percentage of cases settle? Is it 95%?
Easily 95%.
Okay, 95, over 90%. This was clear pretty early on. This case was not going to settle. I mean, we came up with some good ideas when you have a settlement potential. How about this? This happens frequently. People who own masterpiece art, not this necessarily masterpiece, it's an Andy Warhol portrait of Farrah Fawcett. They claim it was worth at least $12 million. Okay, you want to have a showing? You have the two. Okay, you can have it. You know, we'll loan it to you. You want over a period of 5 years, we'll give it to you 8 times, 5 times, whatever. Well, we'll give it to you for 2-3 years. No. Their approach on settlement, is which I deal with in many cases, is, I like to use this phrase, my way or the highway. This case was never going to settle unless you give them the portrait. And when you know that, you handle a case differently than most cases are for settlement. So, for example, discovery. It's very important. A lot of lawyers and law firms build their clients and they spend a fortune on discovery. But if you think a case is going to go to trial, in my opinion, you conduct discovery differently. Now, Todd Egan, my partner, who did a fantastic job, did most of the depositions. I mean, I did a couple of the key depots and he did a great job. But we did the depositions with the understanding that, and when you ask questions at a deposition, people get frustrated when you're a lawyer. Everybody gives a long answer. And sometimes I advise clients give long answers. Why? Because you can't use it against them. What's the purpose of a deposition? To get an admission. You want them to give a short answer, yes, no, or I don't know, or whatever. So you can lock them in, and then if you go to trial, you can try to portray. In fact, sometimes it's not bad when you ask a witness a question. And sometimes I ask a loaded question like, isn't it true you committed fraud? Is it true you killed your wife? But this is a true story. I had a case against someone I sat next to in synagogue, the high holidays. And unfortunately, he worked for Ticketman. He ran Ticketman, a very famous man. Ultimately, after the case, he wasn't involved when they sued my client, a record company. And I asked the question, you committed fraud, didn't you? His answer was, I'm not answering that question. Now, 90% of the lawyers would say, I want you to answer the question, move to strike. I love that answer. I said, that's great. I didn't say that's great. To my mind, I said, that's great. So what happens? Move on. He didn't want to answer the question. Now, when we go to trial, and I put him on the stand, I said, Mr. Blank, I'm not going to mention him. I have one last question, but I'm just going to read it to the jury. Is it correct you committed fraud? I'm not answering that question, was the answer. I rested. other side, try to rehabilitate him. And when I did my closing, I said, you know, Mr. Blank, he was a great witness. And I don't blame him for saying, they sued my client for, that was a case where my client was sued for $15 million. They signed they signed a contract for $20 million. They paid 15. They came to me and they said, you figure out a way that we don't have to pay him the money. I said, okay, I'll try. And I had enough, I had a cross complaint for fraud. We had they owed the money. It didn't matter. So when I went to trial, we had a cross complaint for fraud. I said, you know, Mr. Blank was a great witness. I don't blame him for saying, I won't answer that question. Because if he told the truth, he'd admit that he committed fraud, they'd lose the case. And if they said no, he'd be committing perjury. So of course he answers, I'm not answering the question. So sometimes you never know when you take a deposition. Getting an answer like that is better than getting even an admission because the jury loved it. In fact, they wound up giving the other side 0. My client wound up getting $5 million. I went away on a trip they delivery for 9 days. They came back for punitive damages for my client in that case. So it's important when you take depositions in a case, and everyone does interrogatories, requests for admissions. It's lawyers who answer those questions. There's 2 key things, in my opinion, you need to try to settle a case, to get summary judgment: depositions and getting documents. Documents are the key. People lie, documents don't.
You mentioned summary judgment. Was there an attempt by either side in this case?
Well, that's a very interesting aspect of the case. As I said, I've been practicing for 40 years, and something unique happened in this case that's different than any other case. I'm ready to go we have the case for summary judgment. Have a great team. By the way, let me just say something at my firm. When we go to trial, it's just not me. You know, maybe I have the recognition, but I also have great lawyers. All my lawyers in my firm, they work for us for a long time. So I have it's a team effort. I tell that to everyone. It's a team effort. My 2 assistants at the time, Christy Persky, Heather Hancock, my file clerk, and Rick Lasola. It's a team effort to take a case, work with everyone to build a case. So in summary judgment, we did a good job. We defeated summary judgment. I think they thought they were going to win the case on summary judgment because the painting was there. They had a witness named Craig Nevius, who was a key witness who we were trying to go after during the trial. We defeat the summary judgment. Oh my God, we're going to have to go to trial. That's what happens all the time. Well, here's something unique. University of Texas didn't like the judge. I don't blame him. He understood the facts. He bought our argument. He understood what was going on in this case. But you cannot get rid of a judge other than the beginning of a case. You have a right what's called a CCP 170.6. So what do? I've never seen it. I've spoken to people. No one has ever told me they've ever had it. All of a sudden, they had the law firm of Morrison & Forster. People not familiar, it's one of the national law firms. They were co-counsel with this great Texas law firm. And they had some great lawyers that were doing a lot of discovery from the big firm. Out of the blue, after the summary judgment, we're about to go to trial. An insurance defense firm, who's known for representing lawyers, substitutes in the case as local counsel. I'm thinking, why are they taking out Morrison & Forster? Money's no object to this. Well, what did they do? We go to a hearing with this lawyer, and the first thing the judge says, counsel, we thought we were going to get a trial. I'm going to have to disqualify myself. We had no idea what happened. To this day, we didn't know for years afterwards what happened, and then we found out. We didn't know what happened. We thought maybe he had some illness or something, where he says, I can't handle the case. Money is no object is great. There are lawyers who represent judges when there's claims made against them. Listen, everybody's subject to claims. Even the President of the United States may have claims against them. And the law is that if there's a lawyer who represented you, who comes before you within 5 years or 2 years, I think it's 5 years, then you must be disqualified. So they found a lawyer who represented the judge, who was well known by the other judges, and he disqualified himself. In fact, I'll never forget when we started the trial, we went to a great judge, I think Judge McLaughlin. It's interesting because I like, if I know a judge, he goes, hello, Mr. Mag. Oh, Marty, how you doing? Oh, how, Mr. Counsel? Hey, Mr. Singer, how you doing? When we were introduced to the judge and we went in chambers before the trial, he'd go in everybody. We first, Mr. And we went to the woman who was previously, he knew her. He called her by her first name. So, you feel you're a little disadvantaged. You knew her, but that's okay. We've had other issues. But it was a very interesting thing that I haven't seen before. In any event, that was an interesting thing. And another interesting thing that happened during this case, I'm talking too much. I feel like I'm filibustering, like if we're going to appoint a Supreme Court judge right now. Maybe you should ask another question before I filibuster.
I'd be happy to do so. There's so much material here. We could spend 3, 4, 5 hours or a series. But let me talk a little bit about the whole concept of celebrity trials, because at this point you're galloping towards a trial. You're engaged heavily in discovery. You've got summary judgment motions. You've got the replacement of the judge, all these issues going on. But at the same time, in parallel, you have a lot of publicity relating to these types of cases, which you know very well. So can you talk to us a little bit about how publicity affects these type of cases? And in this particular case, what were the challenges you saw with the media?
Great question and great intro. So first of all, when you represent a celebrity, let me put it this way, 90% of celebrities do not want to go, maybe 99% do not want to sit in a courtroom. And the last thing they want to do is, walk in front with paparazzi cameras or other cameras walking. And in fact, sometimes we've gotten accommodations for a couple of my celebrity trials where we're allowed to park under the building in downtown. They've been great. And some celebrities just don't want to go in a courtroom. Listen, you get rid of it. I have had cases, I'm never going to settle. Then we're saying, well, you got to show up in trial and sit with me. Okay, well, figure out a way to get rid of it. But some people like Ryan, great guy. I've become very close with him. He's a wonderful man, a great guy. And I was so emotional because this was clearly his painting and he should have kept it. And I'm so glad he kept it because I love him. And it was all right. But University of Texas has got money to burn. And so what have they done? They had tremendous publicity. They did things on the early morning shows. They had articles, how RyanO'Neal stole this painting. They had one guy who was their witness who he had been sued for misappropriation or conversion of over $500 million. He was their key witness. He said Ryan stole the painting. In fact, we sued him for defamation. So they had so much publicity. Well, it backfired. You know why? We're ready to start the trial. We have witnesses. University of Texas felt they had a 99% chance of winning. A gift came to us a few days before trial. We get a call from a manager, in fact, for one of my clients, a different client, calls my office, said, oh, by the way, I have a witness, but she doesn't know if she can testify. So what about this witness? Well, she was reading the New York Post. The week of the trial, the University of Texas placed an article about the case. It was a PR piece. It was a big article trying to put down Ryan and how he was taking this painting that didn't belong to him. And the woman was a nurse for Farrah Fawcett before she died. She helped take care of her cancer. We didn't know who our nurses were. And she told her, because in the article it said that these were two paintings, she told her boss, she was now a nanny, oh, I know Miss Farrah. I was there. She told me, this is my painting and that one is Ryan's. Well, you're not allowed to bring in a witness unless you identify them before trial. We didn't know about the witness, and that was the key thing. In fact, maybe one of the most important things that happened in this trial. University of Texas lawyers fought like crazy to keep her out. In fact, we thought the judge wasn't going to allow this key witness. She knew the facts. They fought with us. We had to take a deposition of her on a Saturday. They voir dired her before, and they not only took the deposition, or the night before they tried to intimidate her from testifying. She calls me up. I have men following me. They had private security people following her when she was leaving her work and going shopping, and she was scared. Thank God, because some people say, forget it, I don't want to have anything to do with it. Showed up, great witness, perfect. She had nothing, no agenda. And you want to know something? No publicity? That witness never would have showed up. We wouldn't even known about that witness. So that's sometimes where it backfires. I'm not going to go into other cases I've had publicity. I had a case on Court TV. I got a great witness that came out of that one where someone was watching and all of a sudden we found out a fact. So, but usually when you represent celebrities, it's tough because you want a jury that likes you. Now, here's an interesting thing about a celebrity. RyanO'Neal, most of the people here may not even know who he is. And in fact, because he had success from the 60s at Peyton Place, he did Love Story, he did Paper Moon with his daughter Tatum. They're from the 70s. But he did a show called Bones. He was the father of David Boreanaz. I hate to say it, I didn't watch the show, I represent both of them, but in any event. But I didn't know he was the father. We'll wait till we get to voir dire. But here's the issue. Most people did not know RyanO'Neal when they did the voir dire. We can get into the question of voir dire. But it's an interesting thing when you represent a celebrity, because sometimes you represent a celebrity that you like or the people like. They wanted to portray RyanO'Neal as a man who cheated on his love girlfriend, Farrah Fawcett. Can you imagine? In her presence, or where she caught you, that he was a cad. He was a horrible person. And that was their theme of the case. So should we talk about voir dire?
Yeah, I was going to say that this is a natural segue into talking about jury issues, which the litigators really want to hear, because a lot of people talk about cases and trying cases, but unless you've been to a high-profile celebrity jury trial, it's hard to imagine what an intense environment that is. So talk to us a little bit about jury issues. What do you look for in voir dire, and how do you connect with jurors?
Okay. That is your best time to connect with a jury, is voir dire. It's hard. Some of these lawyers are fantastic. I don't give myself credit, but you win the trial typically with the jury selection. Everyone has said, like the OJ trial, that was a decision of who to be on the jury. It's hard to predict. It was funny. I had a trial once for Roseanne a long time. She told me, don't pick this type of person. I said, why? They hate me. How did I know? So you always try to find out from you, are there people who like you or don't, and you try to keep those people away, and you can, but you want to get people, like, for example, in this case, I wanted to keep off college sports fans, because I figured if you're a college sports fan, like football, you may like the University of Texas. They wanted to get people who maybe didn't like people in the entertainment industry. So like one of the things I ask always in a celebrity case is, who reads tabloids? Who likes tabloids? Who believes they're true? Why? Tabloids don't say anything positive about celebrities for the most part. So then I figure that's a person that doesn't like celebrities. And you want to bring in facts of the case. They try to bring in, well, how would you feel if you found out someone was cheating on you? They want to get people who would associate with that. We're not allowed to get into questions about, representing someone that's worth billions of dollars. You're not allowed to do that. You try to get into other issues. So one of the issues is to try to get into, figure out someone who knows RyanO'Neal. They want to know who. If you knew RyanO'Neal, they didn't want you on the jury. Or it depends. If they question you, what you. So out of the blue, this young woman was questioned, I believe, by the University of Texas lawyer, and said, what do you think of RyanO'Neal? Do you know anything about it? She says, I love RyanO'Neal. And and it's in front of all the jurors who may not even know him, which is great. You think this is the best juror. She's telling everyone he loves him. So, of course, they try to knock him out what's known for cause. The judge said, no, use up one of your challenges, a peremptory challenge. As she's walking out, she's walking past Todd Egan and me, she gives him a hug and a kiss on the cheek in front of the whole jury. And they were whatever. But anyway, so voir dire is a very interesting thing. There are books that are written about it. The best thing is to, try to speak to people who've done voir dires. It's important. because you can have this is the only time you have an opportunity to talk to the jury other than your opening statement and your closing statement. You're not supposed to talk to them. So voir dire is a very important part of the trial and a part of the case.
Well, let's talk for a minute about how do you organize facts and witnesses to present them to the jury, and how do you develop case-winning themes for the jury?
So I think it's important in your opening statement, this is what I do, if you can show we have a timeline of events. So I think we have a timeline if they want to show it to everyone.
Sure, we can put that up for the audience.
Okay, so I think it's important, although this looks like a little mishmash, but what you do in the opening is you go through the chronology, and there's a lot of facts, and I have to thank my partner, Evan Spiegel, for putting this together. He works with our graphic designer, and it's important to lay out the facts because jurors listen, but when they see something, it means something to them. Visual things mean something. And we try to go into history. So, for example, you can see February 97, Ms. Fawcett finds another woman in Mr. O'Neal's house. O'Neal and Ms. Fawcett continue to raise their son together. And then there was a very important fact to show where the painting was. And between 2001 and 2006, the painting was with RyanO'Neal. But unfortunately, when Ms. Fawcett was diagnosed with cancer, we decided, Ryan said, here, you can have the painting there. So anyway, so these are important facts that it's important, in my opinion, because it gets a little complex. Sometimes it's more simplistic, sometimes not. But I think juries will understand things when they say, okay, we don't need the slide anymore, in my opinion. So another important thing is during the trial, how you behave yourself during the trial. I've always said, who wins or loses case? Because many times, like I had that case where my client owed $15 million. That was two corporate entities. And so I say many times, who do they like, the plaintiff or the defendant? So when you try a case, you hope that the jury will like your client more than the other side because they're going to feel sympathy or they want to rule for you. The second thing jurors look at is which lawyer do they like? I know people have been on juries, they say, oh, that lawyer was terrible, he was horrible, or I love that lawyer, excuse me. So it's important that you like the lawyer. So for myself, when I try cases, the state court, you can't do it in federal court. Federal court, you have to stay by the lectern, and ask you questions. Otherwise, you could wind up in, they can lock you up and then the judges won't like it. But in state court, I think I like to move around. I think the jury should be following me, being interested in me. So I walk, and in a state court case, the defense counsel, which is we're furthest away from the jury, plaintiff. So I'd have to walk behind the plaintiff's counsel, and I like to walk in front of the jury without notes and ask questions of the witness. And I use my hands. Coming from Brooklyn, I'm not Italian, I'm Jewish, but it doesn't matter. I like to use my hands. I want the jury to focus on me on the questions. And sometimes if you use a low voice, juror will listen to it more than using loud voices because then they're trying to listen to what you have to say. So I walk. Well, plaintiff's counsel, all of a sudden, as the trial is going on, it's about a month trial, more and more boxes are being brought in. I was wondering if they were putting Farrah Fawcett's artwork in those boxes to block me. They didn't want me to walk past to go in front of the jury, or they put their chair, I'm on a chair, or they move their chair back. I figured a way, you can communicate to a jury without speaking. I would stop and let the jury know they're preventing me from walking past them. That's not good. And ultimately, I had to walk past. I had to say, excuse me. And so these are little things, they thought they were being cool, block them. I'm sure they hated my guts more than they hated RyanO'Neal, but that's okay. That's my job as a lawyer. But it's very important also in a trial to have a theme. You tell it to a witness, you have to think. So what was the theme for us? And for their theme was, I'm representing this lying cheater who stole that painting after she died. She didn't even wait for her body to be cold before he took the painting from her. That's how they portrayed him. I said, there's a case of greed. And I know people are fans of the University. That I don't have to be a fan. If you know college football, there's a color. It's orange, burnt orange, I call it. you can show the board. This is the first board I showed when I came out to do my closing. We have the board that shows greed. Okay, that color orange, I hope it's showing up on your Zoom. I wish I invented Zoom. I wouldn't have to work. My kids or grandchildren would never have to work. But in any event, greed. That's what I said this case is about. They had one painting and they needed two. Why? God forbid that they would put any of her artwork, which is what she wanted. And the jury agreed. This was greed. So it's very important when you try a case, it doesn't have to be a one word, but come up with a theme for your witnesses, come up with a theme that you could present to the jury. And this was our theme. This is a case of greed.
Now, when you package this all up in closing, every lawyer has some really good moments in trial, and every lawyer has a moment in trial where they think, oh no. What were your best moments and your toughest moment in that trial?
What was my best moment?
Yeah.
When the jury came back in favor of RyanO'Neal. That was my best moment in that trial. But well, first of all, I don't know if you can tell, I love speaking. So I love the closing where you can incorporate everything. To me, if we try cases, I love trying cases. I do primarily arbitrations. You cannot have the same impact. But I think that's the best moment. Worst impact is many times hearing you question witnesses. You practice with them. You don't rehearse, and they answer a question. You think to yourself, where'd that question answer come from? So you get plenty of those worst moments. That's not one worst moment. Well, when you get a surprise witness, I should just add very quickly, because I mentioned Toddy, he did a great job cross-examining his expert witness. They wanted to show that was an interesting thing. They didn't not only wanted the painting, they wanted $12 million from my client. They said, if he doesn't give us the painting, we want $12 million. So he had to cross-examine this witness. Wait a minute. If this painting is worth $12 million, why'd you put $600,000 on the insurance policy? I didn't know. Anyway, but that's an important issue you should also know. If you have clients and they claim they own something like this work of art, one of the key issues in the case is, well, who had that painting insured? If Farrah Fawcett doesn't own it, then RyanO'Neal should have it insured. And unfortunately, they had the same business manager. And the business manager didn't do sometimes what they should have done. They should have known who owned it, which is a rarity. But assuming you have a client, it's very important for you transactional lawyers to know if your client owns something, make sure that they have it insured. That was a key problem we had because at the end, that painting was not under Mr. O'Neal's insurance policy.
Well, that's a good takeaway for the transactional and business managers on the video here, because you can learn a lot from a case, not just if you're a litigator, but as a way of improving your business skills. Now, tell us a little bit. Obviously, you had a fantastic moment when the jury came back. Did you talk to any of the jurors after the verdict? Oh,
I forgot to say, in my opinion, talking to the jurors, you know, I'm trying to remember when my first trial was. It was, I think, around 1984, 85. Anyway, I learned the most as a trial lawyer by speaking to the jurors after the trial. I always ask them, what do you say? But I always want to know, what would you like different? And I want to just give this word of advice because I was telling Adam ahead of time. When you try cases or you're in court, less is more. I used to spend too much time. Look, a trial is not a deposition. Jurors are going to get bored. You want to put them up and get them down. Unless there's someone you know they're going to hate, then you keep them there as long as possible, and the juror will hopefully hate them more than they did if they were there for a short period of time. And you never know, but you want to get to the point. For example, you know. So I had a case before Harry Hupp, a federal judge trial. Unfortunately, I represent both Roseanne and Tom Arnold together. They had just gone through a horrific divorce. I think it was the third time back and forth. Hated each other. And but it was very interesting having that trial. I also had a big arbitration with Tommy Lee Jones, where what they do in federal court, which is different in state court, they have timers. And they'll give you, they figure out, okay, you're gonna have a 4-day trial. And they tell you, I don't care if you think 10 days or not, we're gonna give you 4 days. Opening, closing, cross-examine, you're questioning, you got 724 minutes. And you have 724 minutes. So you better use it. In fact, that case that I tried, the other side had been done. They had no time left for the closing. I said, no, you can give them some of my time. The judge said, well, but I felt that I could lose on appeal, even though the judge, but it's very important. Try to be efficient. Try to learn to limit the questions and get them in and out, because juries are going to get bored. Let's face it, they'd rather not be there. I don't know anyone listening on this call wants to be in a jury, especially you're working. Although it was interesting, my case that I had, my longest trial was 10 weeks with this the Ticketmaster case. The other side was filibustering. I thought we were going to lose the jury, but they were all government employees, most of them at the time. They loved it. They'd much rather work. I made that case interesting. At the end of the case, I say how it's important to have the jury like you. When I spoke to like 6 jurors after the trial, and I said, so, what'd you think? And they said, well, they called me Jerry. I said, Jerry? My brother's name is Jerry. He lives in Florida. He's a doctor. How do you know Jerry? No. Jerry for Springer. I said, did you like him? You like Springer? Is that a compliment or a detriment? They said, we love Jerry. We thought you were in charge of that whole courtroom. When everybody else was up, they were terrible. I won't use the word they used. Unfortunately, my senior associate was with me. He said, what'd you think of me? He said, you stunk like the rest of them. So anyway, it didn't matter, but I felt embarrassed. But you do get input as how you can improve. So it's very important. Even if you lose a case, I've lost cases. When you lose a case, I'm trying to think if I lost a trial. Anyway, it's not important. I've lost arbitration. It doesn't matter if you win or lose, irrespective. When you lose a case, just as well, you should go to the jury. You never know. They are your best critique. Why? Because if you're going to try a case, you want to know what they think of you. All right.
Well, that's some great advice, and every one of us can learn from mistakes we made and things that we lost. In this case, it sounds like you didn't have to learn very much at the end of that one. Talk to us for just a second about the use of the timeline. One of our questions that somebody had posted was, were you allowed to use and develop this timeline during the testimony? In other words, throughout the trial, or were you only allowed to use it as a demonstrative aid at the end of the case? Because some judges have different practices in that regard. And that's really important when you're trying to communicate this timeline to the jurors.
So this is important, and I've had timelines like this. You need to show your demonstrative evidence, which is this document. It's not an exhibit, to the other side. And if they object to one item, you can't use the timeline, or it looks weird that you put a Post-it over it or something. So you're also even editing it. So you have to make sure that these are undisputed facts. And in fact, I believe there might have been additional things on this timeline that they objected to that we had to take off. But it depends on the judge. But my experience has been, as long as you can tie in evidence. I had another copy of this timeline, which had all the exhibit numbers on it. And so we could tie it into the judge if they objected. So if you want to use a timeline or any demonstrative evidence like that, you make sure, and the other side has a right to object, and depending upon the judge. So you better be careful as to what you put on the timeline. And they also don't like sometimes use the words we use. Like for example, we put fines another woman in Miss O'Neal's house. They want to say was cheating with another woman in his house. So we said, Your Honor, you don't need to. She found her. What's the difference? It was cheating or not? But it's a negotiation sometimes. And sometimes the judge will say, you know what, Mr. Singer, forget it. You're not going to use the timeline. So I said, okay, I'll take that out. So, and you better have your AV team ready to go to modify, because you got to put it as, now you may not. I like working with poster boards. Now, I don't know, they think the guy was born in the 40s or whatever. I'm not. But in any event, now everything is on the screen. But in any event, you need to make sure if you use demonstrative evidence. So while we were able to use this at the opening, I didn't use this for the closing. This is for the opening. This type of timeline, I would not use for the closing. I would only use for the opening.
Well, that's great advice. It's a great takeaway that you have to be prepared to make a lot of adjustments on the fly, particularly in the modern digital age. And particularly now, Marty, trials are going to be going to the same format that you and I are using right now. Any thoughts on how you connect in a trial on Zoom or video? That must be tough.
Listen, I don't know if anyone's doing trials by Zoom. I don't think you can do it. I don't even know if they're doing arbitrations. I know you can do depositions by Zoom. First of all, I don't think you can do it. You're just going to delay jury trials. And if it's a judge trial, I don't know. I'm not aware. The big issue is criminal case. I don't know any criminal case. I may represent some people who are criminals, but at least I didn't know it when I started representing them. But in any event, that's going to be the big issue is criminal trials. You got to have a jury, and then you have the Speedy Trial Act. But the issue is, I don't know if you can't connect like this. Just like I've done mediations, I have not found they really work. There's great mediators that settle 99% of the case. Now, maybe, I don't know what they're tracking, but the great mediators have told me they've still settled 99%, except if I have a case before them, it didn't sell. Okay, you're the 1%. But in any event, I don't find as effective as being with the person. And I don't know what we're going to do because no one knows what's going to be happening in this world. When they quote have a vaccine or what's going to happen when the flu season comes. But I don't know, Adam, if we do know something more than I know, but I'm not aware that you can actually do a trial yet this way, but we don't know what's going to happen.
We don't. I wish I did know. I wish I did know, but this is a great tool that we have in these kind of video conferences, but I agree with you. It does not replace the personal, visceral, emotional impact of being in the same room with a juror that you can talk to face. Would you agree with that? Of
course. And not only that, the trial, the juries, if you try a case, be careful you don't stare at a jury. You got to glance at them, or you ask your second chair to look at them while you're concentrating. Mm-hmm. The jurors don't like when you are looking at them. You're looking at me? But they don't just listen to testimony. They watch the lawyers. They watch how the people behave. They watch how your client is fidgeting when someone is testifying against them. Mm-hmm. They are observing things just like anyone would be if you were with someone in a room. Jurors don't have to be brain surgeons, but they look at human nature, and you can't tell with a Zoom meeting. Nobody knows I'm wearing shorts right now, quite frankly. It's irrelevant.
Well, I feel the invisible stare of the federal judge you mentioned earlier as we arrive at our 1 hour long time commitment. We have a number of other questions. I'll add one more, and that was, did you make any motions regarding this late substitution of counsel? In other words, that must have been a nasty surprise for you. Was there motion practice on that substitution, whether it would be allowed, or was it a fait accompli?
It's a fait accompli. We can't do anything. They brought in this lawyer. They got rid of the judge. Judge is gone. Boom. Can't bring him back. And we had a tough judge who really worked hard. He had us in his room at 7:30, 8 o'clock. And we started that trial at 9 a.m. on time. And that was hard because I drove to court every day with RyanO'Neal. I got to know him. And so one of my favorite people in the world. And make sure they're there. Don't worry. And be careful. Don't take the freeway when you go to court. Take the streets. God forbid you block. That's another thing that you may not think of. Don't ever take the freeway, and make sure you have Waze. I haven't used that in a while, but for at least since March. But make sure you have ways to think of a way to get to court if you're blocked, because a judge will not tolerate a lawyer coming late.
Well, I
late to my golf foursome. They tell me, when are you showing up? But not in trial when you come late. Do not come late.
Marty, those are some fantastic lessons. Have a theme, develop a timeline, and take the streets on your way to court and be on time.
That's number one. That's the only thing you should remember. Don't be prepared. Don't remember anything, but at least be there on time. That's what's important.
Well, ladies and gentlemen, thank you very much. This has been a true pleasure. It's fun and fascinating. And you know what, Marty, I have a feeling we're going to see you back on another panel because you have so many interesting cases. As I said at the very beginning, collegiality is so important in our profession, and also to share the experiences of our best lawyers so that everybody else in the community can learn from them. Marty Singer, thank you very much. Ladies and gentlemen, Have a great weekend. Have a great, safe time going forward, and we'll see all of each other in court in person someday, I'm sure. Take care, everyone, and be well.
Thank you, everyone. Thanks, Adam. You did a great job.
Thank you, Marty.